Jail Nnamdi Kanu and see the U.S. Army in Nigeria. Trump's threat to shut down Nigerian court. Donald Trump don't come on. Donald Trump don't come. In fact, my dear listeners, Donald Trump has finally spoken after the hearing of Nnamdi Kanu today. Yes, he has really fired back at Justice Omotosho, the judge, the presiding judge. In fact, you really need to hear what he said and what he claimed that will happen if Nnamdi Kanu is jailed. Yes, if Nnamdi Kanu is jailed. My dear listeners, please, if you have not been following up this trial since today, please deem it fit to do so because it will not really augur well if at the end of the day nothing meaningful is gotten. I'm impressed. Now let me take you into the courtroom and hear what a little of what is currently going on. Let's hear this because so much happened while you were away, but I'm trying to bring you back to the session. Watch this.
Corruption charges. They sent her to my case so they can release or smoothen the pathway for the husband and the son. Who have the light? They are facing, it doesn't matter the office. In a corrupt society, that's what happens. They are very, very corrupt. There is a breach of judicial oath. They have violated the judicial oath. They have shown bias according to Supreme Court. They are biased against me. Supreme Court said so. And that is why what is happening in the judgments and rulings concerning me has been happening. Disobedience to superior court orders. Supreme Court said you are biased. But that's what you wrote. You said here, my lord, that the defendant has now applied for bail. Now, as I said earlier, there is a decision of the court taking into consideration all the conditions laid down in Muhammad Abacha v. State. At this stage, I am of the opinion that to make or take a stand on the bail application without first hearing and determining the issue that is glaring in the face, which is the absence of the defendant from the court since 25th of April 2017 until he was produced on the 29th of June. My lord, which was exactly what the Supreme Court did. They said that he did not jump there. These criminals came to my house to kill me. That's what the Supreme Court said. This is in your own court, my lord. So I cannot understand, my lord, why my trial will be conducted contrary to the Constitution of Nigeria that said I must have free and unfettered access to my counsel. It's here.
All freedom lovers, we greet you. In today's proceedings, Nnamdi Kanu continues to defend himself against the charges brought by the federal government of Nigeria bordering on terrorism and membership of IPOB. Today is unique because today he interrogated the court and the prosecution and charged them to prove to him or to show him what law he is alleged to have contravened. You know, this is Nigeria. We practice what we call written laws. If the laws are not made or written by the National Assembly, then they are not in existence. And if the laws have been repealed, of course, repealing means cancelled. If a law is repealed, that law is no longer existing. Now, if a law has been repealed, according to Nnamdi Kanu, he cannot be asked to stand trial on those laws. And he has asked them to show him the law under which he is tried. And it is for the court and the prosecution to say, you are tried under section so and so of this law. And if you do that, you will now check whether those laws are still existent in Nigeria. If they are not existent in Nigeria, then it means the young man may actually be correct to say that there is no charge against him. Of course, knowing that there is no law existing such as the ones we are furnished with. Part of the challenge we have in this court is that the Supreme Court had also ruled that there is nothing like Chapter 45 of Criminal Code. There is nothing like Chapter 45 of Criminal Code. And Nnamdi Kanu is being tried under that Chapter 45 that the Supreme Court has said does not exist. So which law, which defense do you want him to put in a case where there is no written law? For one, I don't know how to defend or interpret such. If the law is not existing, the best thing is to strike out the charge and let the young man go home. And that is why he told them, how can you detain me for over 3-4 years when the law is not existing? When the law has been repealed, when the law has been cancelled? How can you detain me for 3-4 years when there is no law like Chapter 45 of the Criminal Code? So he is challenging the judiciary, he is challenging the Nigerian authorities, he is challenging all well-meaning and all well-thinking Nigerians to find out, to ask, to raise the issue and find out whether in this country the laws have changed to such that you cannot try people when there is no law in place. Can you try people when there is no written law? If you ask me to enter a defense, is it not for me to defend a written law that I may have breached? If you say I breached Section 2 million and there is nothing like Section 2 million anywhere in this world, for goodness sake, are you not jeopardizing my right to fair hearing when you ask me to defend myself against Section 2 million when Section 2 million does not exist? That is a simple question Nnamdi Kanu posed today. And unfortunately or incidentally, the court ruled that it will not answer that question now. They will answer it at the end of trial. And Nnamdi Kanu is saying, how can you try me when there is no law? You must first of all cross the hurdle by bringing up the law that I breached. Then you cannot try me under those laws. If you cannot try me, if you want to try me under a law that does not exist, then it is a breach of my fundamental human rights. So that's as simple as Nnamdi Kanu put it today in black and white.
Now you can see, my dear listeners, that our Nigerian government does not even have anything meaningful to present as evidence to prove. They don't. Nnamdi Kanu entered his defense today, and believe me, he was very, very sound by putting up a very good defense. And you really need to get him correctly. All he said was so perfect that even the judge Omotosho was just confused and didn't know what else to do. Now see what is happening outside the court as we speak.
Don't worry. Are you live already? But we haven't started. It doesn't matter. Okay. I think so. Yeah. Are you ready? Please, find for the it's all right. I see him now. I'm taking myself. Okay. You are best friends. I understand. Yes.
You have to come closer. They are closer now. They are seeing us. Okay. All right.
Mandela.
If we are ready, we say we are ready. Yeah, no problem. Are we ready? Well, greetings, ladies and gentlemen of the media. We have concluded today's hearing in the case of Nnamdi Kanu, and the crowning glory of it was that he put up a very good defense of himself. Even though he was concentrating on the objections raised to the jurisdiction of the court. On that note, the court adjourned for further hearing to 7th of November, when the court expects that he will enter his full defense. Well, having said that, I know a lot of people have raised questions and eyebrows about the propriety of Nnamdi Kanu representing himself. It is his decision to make. He has a right under the Constitution to defend himself, and this case being politically charged, I think the idea or the notion that this is a normal criminal case has to be dispensed with. This is a not normal criminal case at all. If you want to understand the complexity of this case and the true political dimensions to it, you think of the case of Nelson Mandela, Martin Luther King, Obafemi Awolowo, Mahatma Gandhi. These cases were all politically tinged cases masquerading as criminal prosecutions. And these great men I mentioned, at some point in their struggle, at some point in their travail imposed on them by the state, they took the podium and defended themselves. So a politically charged case often comes with some unusual dimensions like this. So because, why? The reason is simple. Lawyers are restricted to very narrow wiggle room when they are doing a case. And that narrow wiggle room can be inimical, can be prejudicial to the interest of the client. When the case has a political dimension to it, that thing needs to be out there. That limitation we have is not expected of the defendant himself. So a lot of times, the defendant himself will make the best defense of his case at that very point in time. That doesn't obviate the fact that the presence of a lawyer in a case is always better. But in certain circumstances, there are exceptions, and the exception is, this one is one of the major exceptions. Thank you. Thank you.
Our motto show himself. I know you'll be feeling happy that Nnamdi Kanu has finally obeyed his word, but unknown to him that what happened today was in favor of Nnamdi Kanu, because now the world has taken note and cognizance of everything, and now the world is fixing an eyes on him. Let's see how he's going to play the politics to deny Nnamdi Kanu his breakthrough. Let's see that very section in the Constitution that found Nnamdi Kanu guilty. In that very file Nnamdi Kanu is holding, we would really like to see that very line where Nnamdi Kanu was accused or charged. Yes, that is what Nnamdi Kanu is trying to say. Am I right? Please share this video. Don't let it end up with you, because it is the only way out to save Nnamdi Kanu out of this mess. Thank you.